Hey everybody, welcome to today's episode of Daily IoT. On today's episode, we're talking patent attorneys. I just got off a call with a patent attorney, and if you remember from many episodes ago, depending on how long you've been following the journey, I pretty much wholesale threw out the idea of pursuing a patent for the Smart Puck, and I gave some reasons for that. A link for the video will be up here if you want to go back and watch that, but I had essentially dismissed the idea until recently. I started to backpedal on that a little bit to the point where through some various contacts, I made some amazing contacts over Labor Day weekend, kind of hustling on the days off, and made some great contacts. But somebody put me in touch with a patent attorney specifically around tech, IP, and patents and things like that, software and hardware, in that very specific genre of patents. And so I got on a complimentary call with them to kind of discuss, do I have something that's patentable and what sort of steps are involved and things like that. And so I wanted to share a little bit of that with you today on today's episode. And so first of all, my biggest question when I was talking to the attorney was, do I have something that is patentable? And unfortunately, from the call, I can't discuss any of the details of that, but the short answer is maybe. And but that's not really the important part. The important part is the time. And so I had made assumptions in my previous video about why I may or may not be eligible for a patent, and some of the things that I spoke with the attorney about confirmed some of those worries. Let's talk about it. So the biggest problem I have is that I went public with this idea on YouTube, and I did that almost a year ago to the day. We're getting close to a week. And basically in the US, you have 1 year of intellectual property protection from the time you release information into the public domain. So in my case, I made a video last year on September 13th, 2017, where I talked about what I wanted to make with the Smart Puck. That means I started the clock on that day. The time started ticking, and I have until September 13th, 2018 to file either a non-provisional or provisional patent application. I'm going to talk about the difference between those based on my very limited knowledge from the phone call with the attorney here in a second. But I have, from today, and I don't know when this video will drop, I have 8 days, including non-business day weekends in there, to file some form of patent application with the patent office. So I need to have filed this thing like yesterday if I want to get this going, because it's a several day process through signing agreements with an attorney and then them preparing the application, and I have to do a ton of work if I want to do that. So basically, after I turn the camera off today, I need to make a decision, yes or no, to pursue this, and then I have to get to work right away to prepare some documents. And I'll keep you posted what route I choose in a future video. But so anyway, that's an important thing to know. 1 year from the time you release stuff into the public domain is your intellectual property protection in America. This varies by country and region, and there's lots of laws everywhere. But for me, the US is a big one, but also Canada. And what I was informed by the attorney is that Canada does not have a 12-month IP protection. They have a 6-month IP protection limit, which means I am no longer eligible to apply for a patent in Canada, which in my product is a big deal because half of the market or more of interested parties for the Smart Puck would be Canadian, obviously, because hockey is a huge Canadian sport. And so I've already disqualified myself for patent rights in Canada. I still have a very short amount of time to do that in the US. And so that's one thing. The other part that I learned today was this idea of a provisional and non-provisional patent application. And I'm going to talk about costs here a little bit as well. So a provisional patent application is, if you've ever watched infomercials and you hear that patent pending, that's what a provisional patent application gets you. You file it with the patent office, and basically it's I have this idea, but I'm not ready to file for a full patent. I need a little bit more time to figure out where I might get funding to pay for the patent and revise the idea a little bit, but you're locking in, basically you're getting first in line for a patent. So if multiple people could be doing a similar thing at the same time, I'm first in line for the patent. And a provisional patent application lasts a year. That gives you 1 year to figure out, do I want to apply for a full-blown patent or not? And again, this is in the US. And so The particular law firm that I talked to, their fee for that was $2,500. And that gives you you can put it on your website, patent pending, which doesn't mean anything. Nobody's reviewed it, whether it's patentable. There's no guarantee that you're going to get a patent. This is literally just I need another year, hold my place in line. Nobody's reviewed this for actual patentability. And so that's a provisional patent application. And again, that lasts for 1 year, in which time you need to, if you would like to pursue it further, need to file a non-provisional patent application. And this is the full scale. I want to actually pursue a patent through the patent office. And you have to submit all the documents and everything for that. The price I was quoted for the law firm that I dealt with that's a fixed fee, $14,000 just to get it to filing. At that point, as I was educated by the attorney, it takes about a year for the patent office to look at that, and then there's going to be some back and forth. They're going to ask questions, and you're going to negotiate back and forth, and he was saying there's costs for each of those negotiation rounds of how you want to modify the wording and things like that to get to eventual patent, which could take several years. Average price, he said, for each round of back and forth with the patent office is going to cost you about $3,500. And so full cost from if you do a provisional to a non-provisional application, you're looking at $40,000 to $50,000 to obtain a patent. Now, again, after you've spent that $14,000 to file the non-provisional application, that's still not a guarantee that you will get a patent. The patent office could come back and say this is not a non-obvious extension of existing technology or not something novel and new, and so we're rejecting it. You're still out that $14,000 plus an additional $2,500 if you filed for a provisional application before that. And so we're talking, for big companies, that's nothing. This is just chump change, no big deal. That's why they apply for lots of patents, like your Microsofts and places like that, Google. But as, again, a single founder, I can't just say, oh yeah, sure, here's $30,000, let's see what happens. And so that's something to consider. However, again, and I'm not going to rehash my opinion on the value of patents, but I wanted to at least go down that road a little bit more. It was a free consult. It didn't cost me anything to learn some of these things about the ins and outs of how the patents would work and the path that you could take to get there. And so that was pretty much it. I'm trying to think if there was anything else from the call. Again, it's hard to say, and he was very open and honest with me. It's hard to say if you have something patentable based on what I've got with the Smart Puck. And the big lesson learned was if you're even remotely interested in pursuing a patent, don't do what I did, which is head straight to YouTube and tell everybody that you have this great new idea. I don't regret doing that. I still think I'm fine, but I am trying to decide specifically, and this has to do more with my licensing issues with sports organizations, of whether I would like to pursue and apply for a provisional patent, not so I can be cool and say yo, I got patent pending status, but is that something that will help me with negotiations if I need to get into a licensing umbrella? Again, that was a different video where I talked about licensing issues with sports organizations, but just something I'm considering. I'm still not super high on the idea of patents, and I definitely still think the system is broken, at least in the United States, of what's patentable and patent trolling and things like that. But anyway, just wanted to fill everybody in on, again, I'm just trying to share the journey, the stuff I'm learning as I'm going through, and that was my brief summary of the call with the patent attorney today. So that's going to do it for today's episode. Question of the day, more of a general share your opinion. What do you think about patents in general and patent law specifically in the United States? I would love to hear your opinion in the comments below. Otherwise, thank you so much for watching. I appreciate everybody joining in for Daily IoT, the show where together we're learning how to make the Internet of Things one day at a time.